In life, there can be alternatives, and so does in an obligation. And that's what we're going to discuss for today's report. By the way, I am Michelle Sanet Felicitas, and I am one of the presenters for today's discussion. And we will be talking Section 3, Alternative Obligations. So, there are two kinds of obligation according to the plurality of object, and those are alternative and facultative obligation. And mo na siya ato ang main topic for today's discussion. So, Article 1199 provides that a person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. But before we begin with Article 1199, let us first tackle the kinds of obligation according to object. So first we have simple obligation. It is where there is only one prestation. So what does prestation mean? So actually this was discussed to us. Maybe na-discuss ni siya atong chapter 1 or chapter 2. Correct me if I'm wrong, pero I think chapter 1 yun to siya. And prestation, by definition, it is the subject matter of an obligation or a conduct required that is to be observed by the debtor. So it can be the delivery of a car, or the delivery of a ring. So for example, sa simple obligation, we have here Thanos promised to repair the car of Thor. So sa aning nga example, ato ang prestation is the repairment of Thor's car. So ikaduha, we have compound obligation. Now from the word compound, murag bilhan na nato bangag it's more than just one prestation. It deals more than just one object. And so compound obligation, it is where there are two or more prestations. And then compound obligation can either be conjunctive or distributive obligation. So when we say conjunctive, it is where there are two or more prestations, and all of those prestations are due. Whereas kung maingon ta og distributive obligation, it is where there are two or more prestations gihapon but only one is due. And here's a distributive obligation. It can either be alternative or facultative, and that is what we are going to discuss for today's report. So now, what is alternative obligation? Well, in essence, Article 1199 states that alternative obligation is when several prestations are due, but the payment or the performance of one of them would be sufficient. Meaning, naay duha or more than duha ka prestations nga kailangan ihatag. Pero, the delivery of one prestation or the performance of one prestation would be sufficient, would be enough para nga ma-extinguish ang obligation. So, example, Thanos promised Thor to deliver his car or his ring or his house on December 25, 2022. So here, Thanos does not have to deliver all these three things enumerated. So, dili kailangan nga i-deliver ni Thanos kay Thor ang iyang house, ang iyang car o ang pati na pud ang iyang ring. So pwede nga bisag ang car lang ang iyang deliver, it would be enough para nga ma-satisfy ang obligation o para nga ma-extinguish pud ang obligation. So question, can Thanos compel Thor to accept half of the car and half of the house? Well, the answer is given to us by the second paragraph of Article 1199. This is what the second paragraph of this provision implies, that the creditor cannot be forced by the debtor to accept half of the house or half of the car, and because it would be very impractical masano nga half lang sa house or half lang sa car ang ihatag ni Thanos kay Thor. So that is Article 1199. So now let's move on to Article 1200. Article 1200 states that the right of choice belongs to the debtor unless it has been expressly granted to the creditor. the debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of obligation. So, sa alternative obligation, di ba kay there are two or more prestations but isa lang ang ihatag. And then, it will satisfy na dayon the obligation. So, logically, the next question would be, who will decide on what prestation should be given? Who has the right of choice? So, Article 1200 says that the right of choice belongs to the debtor. So, sa debtor ang naay right to choose kung unsa nga prestation ang dapat nga ihatag. But, naay sumpay. Unless it has been expressly granted to the creditor. So, general rule, si debtor gid ang naay right to choose what prestation should be given. But, pwede pod nga si creditor ang naay right if ever mao na ang naagrihan nila ni debtor. For example, Thanos promised to Thor to deliver his car or his ring or his house on December 25, 2022. And then, if sa contract ni Thor o ni Thanos, walay nakabutang kung kinsa ang naay right of choice, and then si Thor, gi-insist gyud siya nga kanang ang car gi dapat ang i-deliver ni Thanos sa iya. So here, Thor is demanding nga ang car gyud ang dapat i-deliver. So, question, is Thanos bound by the choice of Thor? Of course not, because Thor, as a creditor, he is not the one who is given the right of choice. That is absent in the stipulation. So, 'di ba general rule man nga kung wala na butang sila ang kontrata kung kinsa ang naay right of choice, automatically si debtor naman gyud ang pwede makapili kung unsa nga prestations ang iya ang ihatag. So, in this case, automatically by the application of Article 1200, si Thanos mo'y naay right of choice. And then, si Thanos, pwede nga dili niya sundon ang gusto ni Thor, which is, pwede nga ang ring ang iyang i-deliver because ani nga case, siya mo'y naay right of choice. So, that's Article 1200, first paragraph. Let's discuss the second paragraph. So, the second paragraph of Article 1200 provides that the debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of obligation. So, meaning, ani nga explanation, it means nga ang article naghatag pud siya og limitation sa right of choice ni debtor. So, dili pwede nga ang pilion ni debtor nga prestation kay those that are impossible, unlawful, or those prestations which could not have been the object of their obligation. So, for example, Thanos promised Thor to deliver his car or his ring or 1 kilo shabu or the star in the sky on December 25, 2022. So, if we apply Article 1200, Thanos cannot deliver or cannot choose the third prestation, which is the delivery of 1 kilo shabu, since it is unlawful. And also, he cannot choose the prestation number 4, which is the star in the sky, because it is impossible. So, ani nga example, ang options lang yun, pwede lang yun nga pilion ni Thanos is his car or the delivery of his car or the delivery of his ring. So that's Article 1200. So now let's proceed to Article 1201. Article 1201 states that the choice shall produce no effect except from the time it has been communicated. So, simply said nga, ang imuang choice of prestation, wala pa siya effect kung wala po di mo na siya na communicate to the other party. So, wala pa ni mo na ingnan ng other party, which means nga, wala pa po ni mo siya na nahatagan og notice as to what prestations you have chosen to give to that person. So, ani nga case, alternative obligation pa siya. But, what if you have already communicated it to the other party? Example: Thanos promised Thor to give his car or his ring or his house, and then Thanos told Thor that he will give his car to Thor. So, ani nga example, na-communicate na ni Thanos as to what prestations he have chosen to deliver to Thor. So, what would then be the effect? So, accordingly, ang obligation then ceases to be an alternative obligation. So from the time the obligation ceases to be an alternative one, it then becomes a simple obligation. Why? Simple, since isa na lang ka prestation ang nabilin. So in our example, it would then be that the a simple obligation of Thanos is to deliver his car to Thor. And then another nga effect pod is once properly made or communicated is irrevocable, meaning nga dili na siya dapat nga ma-change. So pag ang debtor nakakuan na siya, nakapili na siya, and then kung unsa nga prestation niya ihatag, and then yan na ignan si creditor, dapat nga dili niya ilisan. And then what if si creditor mo na ay right of choice? So ani same lang japon ang mahitabo, no? The obligation then ceases to be an alternative obligation, and then irrevocable na po dayon ang choice. So note, the law does not require any particular form about giving notice. So pwede ra nga verbally or pwede ra pod nga i-communicate ni debtor through sa messenger or sa email. Simple as that. So that's Article 1201. Article 1202 provides that the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. So, aning article, the question would be, when does the debtor loses his right of choice? And what is the effect when only one of the prestations is practicable? The answer would be the obligation then converts into a simple obligation. Example: Thanos promised Thor to deliver his car or his house or 1 kilo shabu or a star in the sky. So basically, object 3 and 4 should not be an option because those are unlawful and impossible. So dili na siya option, so ligwak na siya ganun. So but then before pa nga maka-decide si Thanos kung unsa nga object ang iyang ihatag, kung a car ba or ang house, an earthquake occurred, and then subsequently it destroyed the house of Thanos. Thus the only object left is the car. So basically, ang car na lang ang pwede nga i-deliver ni Thanos kay Thor. So, and then Article 1202 provides that in cases like in our example, the debtor then loses his right of choice, and then the obligation is then converted into a simple obligation. So that's Article 1202. Let us then jump on to Article 1203. Article 1203 provides that if through the Creditors Act, the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages.
So this article gives the rule when the debtor cannot exercise a right of choice because of the creditor's actions. So as stated in this provision, Article 1203, the latter or the debtor can rescind with damages. Example: Thanos promised to teach Thor Oblicon subject, the law and obligation contract subject, in year 2021, or to give him his car or his house. Now, in 2021, Thor went abroad and he cannot be contacted by Thanos. So, here in our example, Thanos cannot has lose the right to choose the first option, which is tuluan si Thor og Oblicon as subject. And so obviously because of Thor's action, Thanos can cancel or rescind his contract, and he may also claim for damages. Note, ang giingon lang is may rescind. It means nga dili siya automatic nga ma-rescindayon ang contract. The law implies that the debtor may allow it to remain in force insofar as the possible choices are involved. So if he chooses not to rescind, so he can either give or deliver his car or his house. And then because of that, Thor will not be liable for damages. So atong timan ano, if Thanos chooses to rescind, he may claim for damages. But if he did not choose to rescind, he cannot claim for damages to Thor. So that's Article 1203. Let's move on to Article 1204. Article 1204 provides that the creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared or that of the service which last become impossible. Damages other than the value of the last thing or service may also be awarded. So, this provision talks about the effect if one or some or all the prestations or the things the debtor promised to deliver got lost. So, kani siya nga provision, naghisgot siya kung unsa ko na ang mga effect kung ang usa or ang uban or ang tanan nga prestation nga gi-promise ni debtor nga i-deliver kay nawala. So, ang kani po siya nga provision, it also talks about it also gives alternative rights for the creditor when loss or impossibility occurs before the debtor's choice. Note, for this provision to be applicable, dapat nga 1, the right to choose belongs to the debtor, and then ikatuha, the loss or impossibility happened before the selection was made. If some of the object was lost or become impossible through the fault of the debtor will not be liable. Why? Because he has the right of choice, and the obligation can still be performed since ang uban naman sad ang nawala, dili man sad ang tanan. So, what if all things got lost because of debtor's fault? This is when Article 1204 enters. First paragraph of Article 1204 states that the creditor shall have a right for the indemnity for damages since the obligation can no longer be complied with. If the cause of loss is a fortuitous event, basically it's not the fault of the debtor. The general rule may then be applied, which says that if ang prestations kay nawala through a fortuitous event, then ang obligation should be extinguished.
The phrase or the compliance of the obligation has become impossible refers to an obligation to do, and the phrase the indemnity shall be fixed taking as a basis the value of the last thing which disappeared refers to an obligation to give, and the phrase or that of the service which last become impossible refers to an obligation to do. Example: Thanos obliged himself to deliver to Thor either object 1, 2, or 3. Now, if all those object was lost because of the fault of Thanos, then the value of the last thing lost plus damages must be given to Thor.
The basis for indemnity is the value of the item 3. It is because when object 1 and 2 became lost, in order siya nawala, the obligation has been converted to a simple obligation, and that is an obligation to give the third object or the third item to Thor. And dayon, sa aning atong example, when object number 3 became lost, the value of the object number 3 has then becomes our basis. Now suppose object 1 and 2 was lost because of a fortuitous event. Then later, object 3 was destroyed because of the fault of Thanos. Would Thanos be liable? Yes. It is because when object 1 and 2 was lost, the obligation has then been converted into a simple obligation, and that implies an obligation to give the object 3 to Thor. But what if baliktad? What if object 1 and 2 was destroyed by the fault of Thanos and object 3 was lost because of a fortuitous event? Would Thanos still be liable? Well, Thanos has the right in the world to destroy object 1 and 2 since he is free not to select those objects. Now, by destroying object 1 and 2, it means that Thanos is choosing object number 3 para i-deliver niya kay Thor. And by that, the obligation has then been converted into a simple obligation. And as a general rule, if the thing was lost through a fortuitous event, then the liability shall be extinguished. So to answer the question, would Thanos be still liable? No, because object 3 was lost because of a fortuitous event. That's it. That's Article 1204. Now let's jump on to Article 1205. Article 1205 provides that when the choice has been expressly given to the creditor, the obligation shall cease to be an alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. 1. If one of the thing is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. Number 2, if the loss of one thing of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which through the fault of the former has disappeared, with a right to damages. 3. If all the things are lost through the fault of the debtor, the choice by the debtor shall fall upon the price of one of them, also with indemnity for damages. The same rule shall be applied to obligations to do or not to do in case 1. Some or all the prestations should become impossible. Article 1205 is applicable when the right to choose belongs to the creditor. So, sa ani nga provision, makita sa first paragraph, nga for the choice to belong to the creditor, the right must be expressly given to the creditor, and the obligation shall cease to be an alternative obligation from the day the selection has been communicated to the debtor. It may be written or verbal communication. So, bago pa ma-communicate ni creditor ang ang choice, the responsibility of the debtor shall be governed by the following rules. First, when a thing is lost through a fortuitous event, the creditor may choose from the remaining item. Second, when a thing was lost through the debtor's fault, so the creditor may choose from the remaining item or the price of one item lost with a right to damages. Third, when all things are lost through the debtor's fault, the creditor may choose a price from any of the item lost, also with indemnity for damages. And then fourth, when all things lost through the through A for tweetus of them. In this case, Article 1174 shall apply. The obligation shall be extinguished. Example, Thanos obliged himself to deliver either object 1, 2, or 3 to Thor at Thor's choice. Now, before Thor could communicate his choice, object number 1 were destroyed by the fault of Thanos, and object number 2 were lost through a fortuitous event. Now, si Thor, he may demand object number 3 to be delivered or the price of object number 1. Either case, si Thor na siya right to claim for damages. So, base notan na mo nga nung object number 1 naman, ang price lang man sa object number 1. It is because dili pwede ang object number 2 kay nga no. Ang object number 2, it was lost through a fortuitous event, and it was said that in Article 1174, if ang obligation, if ang prestation was lost through a fortuitous event, then the obligation shall be extinguished. So, dili na to kalimtan ang last part sa Article 1205. So, it says that the same rule shall apply to obligation to do or not to do. Now, we're done with the alternative obligations. Now, let's compare it to facultative obligations. Article 1206 provides that when only one prestation has been agreed upon, but the obliger may render another in substitution, the obligation is called facultative. The loss or the deterioration of a thing intended as a substitute through the negligence of the obliger does not render him liable. But once the substitution has been made, the obliger is liable for the loss of the substitute on the account of his delay, negligence, or fraud. So, Article 1206 actually defines facultative obligation. Facultative obligation is when only one prestation has been agreed upon, but the obliger may render another in substitution. Example, Thanos promised to give Thor a car, but it was also stipulated that Thanos could also give his house as a substitute. So in this obligation, only the car is due. Dili apila na ang land since ang land kay substitute lang siya. So if the loss of the car is through the fault of Thanos, then Thanos will be liable. The second paragraph of Article 1206 provides that the loss or deterioration of a thing intended as a substitute through the negligence of the obliger does not render him liable. Meaning, nga ang loss sa object that is intended as a substitute, in our example, is ang balay ni Thor, was because of ni Thanos, ang balay ni Thanos was because of Thanos' fault himself, will not render him liable since substitute lang man ang balay. But note, naapay last sentence sa second paragraph. It says, but once the substitution has been made, the obliger is liable for the loss of the substitute on the account of his delay, negligence, or fraud. Meaning nga, from the time na anay substitution, so dili na ang car ang ihatag, but ang house na ni Thanos, ang ihatag ni Thanos kay Thor, then the loss of the substitution will make Thanos liable if the loss was through his delay, negligence, or fraud. So now, let's distinguish alternative obligation from facultative obligation. So in terms of the number of prestations, sa alternative obligation, there are various things or prestations are due, but the giving of one prestation is sufficient. And then sa facultative, only one thing is principally due, but the other may be given to render payment or to fulfill obligation. So sa facultative, pwede siya, isa lang ang due, pero pwede pod nga na ay substitution. So in terms of the right of choice, See, sa alternative obligation, it could either be the debtor or the creditor, while sa facultative, it is only the debtor. Now, if there's a loss through a fortuitous event, so under the alternative obligation, the loss of one or more of the alternatives does not extinguish the obligation, while the facultative obligation, the loss of the thing due extinguishes the obligation. Now, if there's a loss through the debtor's fault, through the fault of the debtor, so under the alternative obligation, if the right of choice belongs to the debtor, it will not make him liable. But then sa facultative obligation, it will make the debtor liable. Now, what if one of the prestation is illegal? And under the alternative obligation, the other prestation may be valid and the obligation remains. But under the facultative obligation, the nullity of the prestations agreed upon invalidates the obligation, and the debtor is not bound to choose the substitute. Now, what if it is impossible to give? Under the alternative obligation, if it is impossible to give except one, the last one must still be given. Now, under sa facultative obligation, if it is impossible to give the principal, the substitute does not have to be given. So that's my part for today's reporting. I hope that everyone learned something from my discussion, and my co-member for today's report will continue the report on section 4. Thank you.
My name is Arian Marie Lugodiana, and I am here to tackle about the continuation of my groupmates discussion about joint and solidary obligations from Article 1215 to 1222. So, Article 1215 says that novation, compensation, confusion, or remission of the debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation without prejudice to the provisions of Article 1219. The creditor who may have executed any of these acts, as well as he who collects the debt, shall be liable to the others for the share of obligation corresponding to them. So, there are four legal terms on Article 1215. Number 1 is the novation. So, novation, it results in the extinguishment or modification of an obligation. So, novation is the modification of an obligation by, number 1, changing of the object or principal conditions of the obligation. Or number 2, substituting the person of the debtor. Or 3, subrogating a third person in the rights of the creditor. So, for example, Jad and Princess are solidarily liable to Kate and Diane, solidary creditors, for the payment of 300,000 pesos. Later, Jad and Kate agreed that instead of paying 300,000, Jad will only give his motorcycle. So, the obligation to pay 300,000 was extinguished, but nag-create siya og bagong obligation because which is to deliver the motorcycle of Jad. So, it also create modification as to the object of the obligation. Question. Suppose it was only Jad and Kate who agreed on the novation. Is Princess bound to comply with a novation? The answer is no, because she did not consent to the novation. So, in the creditor, so Dayan, the rights of the creditor to proceed against Kate. So, the right of Dayan is to proceed against Kate. So, the legal terms number 2 is the compensation. Compensation takes place when two persons in their own right are creditors and debtors of each other. So, compensation may be total or partial. So, in partial compensation, the other creditors who have not caused the compensation shall have the right to reimburse to the extent of that their rights are diminished or affected. So, in compensation, if the compensation is total, the obligation is totally extinguished. So, for example, I will only give the example of the book. So, Jad and Princess are solidary debtors of Kate and Dayan. So, solidary creditors of 500 pesos. In another obligation, Kate is indebted to Jad for 500,000 pesos. So, the two obligations have the same due date. Here, there is automatic compensation and both obligations are totally extinguished, there being total compensation. So, si Jad is na siya'y bayro nun kang Kate, also si Kate na po siya'y bayro nun kang Jad with the same total amount. Then, so, also, B is Princess is liable to Jad for 250,000 pesos. Also, Kate is liable for Dayan for 250,000 pesos. The next one is the confusion. Confusion or merger takes place when the character of creditor and debtor are merged in the same person. It refers to the merger of the qualities of the creditor and debtor in one of the same person with respect to one and the same obligation. Also, confusion may be total or partial. So, in partial confusion, the other creditors who have not caused the confusion are to be reimbursed to the extent that their rights are diminished or affected. So, if the confusion is total, the whole obligation is extinguished. The creditor causing the confusion is obliged to reimburse the other creditors, and the debtors benefited by the extinguishment of the obligation are obliged to reimburse the debtor who made the confusion possible. So, for example, I will also give the example of what is in the book. So, for example, Jad and Princess issued a negotiable promissory note in favor of Kate and Diane. So Jad and Princess bound themselves as solidary debtors to Kate and Diane, solidary creditors. So Kate and Diane endorsed the note in favor of Jane. Jane in favor of Russell. And Russell in favor of Princess. So here, confusion takes place because the characters of creditors and debtors are merged in the person of Princess. So the solidary obligation is extinguished. So Jad is liable to Princess for Jad's share in the obligation. The last one would probably remission. So remission is the act or liberality whereby the creditor condones the obligation of the debtor. So remission is an act of pure liberality by virtue of which the creditor, without having received any compensation or equivalent, renounces his right to enforce the obligation, thereby extinguishing the same either in its entirely or in the part or aspect thereof to which the remission refers. So the remission in this part, or the remission or condonation referred to in Article 1215 may be total or partial. So for example I will only give the example of the book. So Jad and Princess are solidary debtors of Kate and Diane. So solidary creditors of 500,000. So Kate remitted the obligation in favor of Jad on the due date. So the solidary obligation is extinguished because there was total remission of the obligation. So Kate is liable to D for his share in the obligation because C's act is prejudicial to, or Kate's act is prejudicial to Diane. Jad cannot ask reimbursement from Princess because the remission is essentially gratuitous or without consideration. If Jad were to be allowed reimbursement from his or co-debtor, Princess, Jad will be enriched at his expense of Princess. Next, Article 1216. The creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. In Article 1216, it means that the creditor has the rights where to collect the payment against any of the solidarity debtors or some or sila tanan. To answer the question, against whom creditor may proceed for payment. So, asa daw maningil ang creditor sa payment. For example, Jad, Princess and Kate solidarily owes Diane the amount of 6 million pesos. Then Diane can collect the payment from Jad, Princess, or Kate alone, or from the two of them, or all of them simultaneously. If Jad pays Diane 2 million pesos, the latter can still go against all of them for the balance as long as the debt has not been entirely satisfied. Next. So, Article 1217. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. He who made the payment may claim for his co-debtors only the share which corresponds to each, which with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. So, this article gives rises to the effects of payment by a solidary debtor. So, number one, between the solidary debtors and creditors. So, payment by one of the solidary debtor extinguishes the obligation. When speaking of payment that extinguishes an obligation, the law refers to payment in full. The law gives the creditor the right to choose which offer to accept if two or more solidary debtors offer to pay under Article 1217. So, for example, I had an example. So, Jad and Princess are solidary debtors of Kate to an amount of 500,000 pesos. If Jad and Princess offers to pay, Kate has a right to choose as to which offer to accept. So the first paragraph, um, it means that the creditor has the right to choose which offer to accept. Then, for example, in the second part, the second paragraph, which is among the solidary debtors. So, after payment of the debt, the paying solidary debtor can demand reimbursement from his co-debtors for their proportionate shares. Legal interest shall apply only from the time of payment. So, for example, in continuation to the example of paragraph 1, suppose Jad paid the whole amount of 500 pesos. So Jad may claim for reimbursement to Princess with interest. So if if payment paid after maturity, interest shall run from the date of payment until reimbursement is made. So if paid before maturity, interest shall run from maturity until reimbursement was made. So if Jad paid on due date, he can ask for reimbursement from Princess without interest. But if Princess paid after 1 year, she will pay an interest from the due date up to the time she pays reimbursement. So the third one is among the solidary creditors. So the receiving creditors or are jointly liable to the others for their corresponding shares. So I will give an example to the third paragraph of 1217. So Article 1217. So example. So I example, Kate, Diane, Justine are solidary debtors of Jane for an amount of 200,000 pesos. So Kate paid Jane the amount of 200,000 pesos. So Kate has the right to demand Diane and Justin for reimbursement. So Kate and Diane are proportionally liable to Jane for Justin's share. But at the end, Kate and Diane will recover when when Justin's finance will improve. Next, the Article 1218. So, payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. So, when the solidary debtor pays the obligation, so he is entitled, as a rule, to reimbursement from his co-debtors. So, kung nagbayad daw ang ilang isa ka kauban. So, kadtong nagbayad, he is entitled to collect reimbursement by to his co-debtors. Co-debtors. So, Article 1218 mentions two cases. Two cases. So, when the paying debtor is not entitled to any reimbursement. So, when the obligation has already prescribed or become illegal, the obligation is extinguished. Hence, technically, there is no more obligation to comply with. So, there are two cases. So, the prescription. So, prescription, one acquires ownership and other real rights through the lapse of time in the manner of and under the conditions laid down by law. So, for example, is Jad and Princess are solidarily indebted to C in the amount of 1,000 pesos. The debt the debt prescribed. So, if Jad nevertheless paid the debt, he cannot collect from Princess the share corresponding to the latter. So, neither can Jad recover from Kate. So, when a right to sue upon a civil obligation has lapsed by extensive prescription, the obligor cannot recover what he has delivered or the value of the services he has rendered. So, example, let's proceed to illegality. So, illegality is the payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has become illegal. For example, is Jad and Princess are solidarily bound to deliver 10 carabaos to Kate for slaughter purposes. Later, the lawmaking body passed law which prohibits the slaughter of carabaos. So, if Jad nevertheless delivered the carabaos, knowing that the slaughter of carabao is already prohibited by law, he cannot get any reimbursement from Princess because the payment was made after the obligation had been illegal. So, I am going to give you the prescriptive periods of actions. So, by prescription. By prescription. So, prescription acquires ownership and other rights through the lapse of time in the manner of and under the condition laid down by law. In the same way, rights and actions are lost by prescription under Article 1106. So the following actions must be brought within 10 years from the time the right of action accrues. Number 1, upon a written contract. Number 2, upon an obligation created by law. 3, upon a judgment. Under Article 1144, the following actions must be commenced within 6 years. First, upon an oral contract. Second, upon a quasi-contract under Article 1145. So, the following actions must be instituted within 4 years. So, first, upon the injury to the rights of the plaintiff. Second, upon the quasi-dialect under Article 1166. The statutes of limitations, however, may be superseded or modified by a contract between the parties. Next, Article 1219. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt has been totally paid by any one of them before the remission was effected. So, effect of remission of share after payment. So, nauna ang pagbayad before na ay remission or waiver. So, the waiver as of no effect. So, wala na'y obligation nga i-waive because bayad na siya. If the remission is made, nauna ang pag-waive, adisir ang payment, it is a case of solutio indebiti or unjust enrichment. Nagbayad ka, and then after all, wala naman kay dapat nga bayaran. So, for example is Jad and Princess solidarily bound themselves to pay Kate 100,000. So, Jad himself paid the whole amount of 100,000. But later, Kate, after the payment, waived the share of Princess. So, since aning example is nauna ang payment, adisir ang pag-waive. So, Jad can still recover reimbursement from Princess because bayad na siya. So, in case pag nauna ang waiver, dili na ka dapat magbayad og reimbursement because the obligation is extinguished. However, Jad can demand the return of 50,000 from Kate under the principle of solutio indebiti. So, the purpose of this article 1219 is to forestall fraud whereby the debt having been paid, the creditor who does not stand to suffer any loss or damage remits the share of a particular debtor. The article also secures equality and justice to the paying debtor inasmuch as the payment benefits his co-debtors. Next, Article 1220, the remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. The reason about this article is that the debtor who obtains remission pays nothing to the creditors. Remission is essentially gratuitous. It is really a donation. Observes that this article applies only when the whole obligation is remitted. So, it has no rights to reimbursement in case of remission. For example, Jade and Princess executed jointly and severally a promissory note for 2,000 in favor of Kate, remitted the whole obligation out of regard for Jad. Jad here is not entitled to reimbursement from Princess, since Jad did not pay anything to Kate. If only 1,300 pesos is remitted, Princess is still liable to Kate for 700 pesos. So Princess has no obligation to reimburse Jad for the 300 pesos of Princess' share affected by the remission for the same reason that no payment was made by Jad. Next. So Article 1221, if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall extinguished. If there was fault on the part of any of them, all shall be responsible to the creditor for the price and the payment of damages and interest, without prejudice to their action against the guilty or negligent debtor. If through a fortuitous event the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay, so through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. So, this article gives rises to the rules in case thing has been lost or prestation has become impossible. So, if the thing is lost or the prestation becomes impossible, the liability of the solidary debtors depends upon whether or not there is fault on delay. So, number 1, so loss is without fault and before delay. So, for example, if Jad, Princess, and Kate promise solidarily to deliver to Dayan a particular truck valued at 15,000. So, the obligation shall be extinguished if the truck is lost or destroyed through a fortuitous event. without the fault of Jad, Princess, and Kate, and before they have incurred in delay. Number two is lost is due to fault on the part of a solidary debtor. So, ang sala daw is naa sa solidary debtor. So, for example, if in the preceding example, the truck was lost through the fault of Kate, Jad, and Princess, shall also be responsible to the Yan for the price of the truck as well as damages, although Jad and Princess were not at fault at all. So um, Jad solidary obligation is in essence of a mutual agency. So as far as the creditor is concerned, the fault or delay of one solidary debtor shall be the fault or delay of all the solidary debtors. So, ang sala sa isa ka debtor kay sala sa tanan debtors. So, Jad and Princess, however, can recover from Kate the guilty or negligent debtor the full amount of such price and damages if Jad and Princess have already contributed to the price of the truck, the price of the truck. If D recovers the price and damages from if Diane recovers the price and damages from Kate, the latter cannot claim reimbursement from Jad and Princess because he alone was at fault. So now lost is without fault but after delay. So example, if the truck was lost through a fortuitous event but after a demand was made upon Kate and Diane can still recover damages from Jad and Princess or both of them without prejudice to the right of the action of the latter against Kate following the same rule in number 2. So the default of Kate makes all of the solidary debtors responsible even for a fortuitous event. Next, Article 1222. So, a solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him. So, or pertains to his own share. So, with respect to those which personally belongs to the others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. So, in Article 1222, defenses available to a solidary debtor. So, in actions filed by the creditor, a solidary debtor may avail himself of the following defenses. So, number one, defenses derived from the nature of obligations. So, for example, Judd and Princess are solidarily liable to Kate in the amount of 4,000 pesos. The entire debt of Judd and Princess was paid by Diane in an action by Kate against Judd. So the latter can raise the defense of payment by virtue of which the obligation was extinguished. So a defense derived from the nature of obligation is complete defense because it nullifies the obligation or renders it ineffective. So other examples are fraud, prescription, remission, illegality or absence of consideration, non-performance of a super suspensive condition, and etc. So number two is defenses personal to or which pertains to share of debtor sued. So example, if the action by Kate is against Princess and Princess was insane at that time, the obligation was contracted. So Princess can put up the defense of insanity with respect to the entire obligation. This defense is personal to be alone. To Princess alone. So it is complete defense. So other examples are incapacity, mistake, violence, and minority. So number three is defenses personal to other solidary debtors. So in the two preceding examples, so the defense of insanity or non-fulfillment of the suspensive condition is not available to Judd as to release him from his liability for his share in his obligation. So in other words, A may avail himself thereof only as regards that part of the debt for which B is liable. Hence, having only a partial having only a partial defense. So Jad is still liable for 2,000 pesos. So his share in the obligation. So that's all. Thank you for listening and I hope na amoy natun-an sa among discussion and God bless everyone.